Okay, good afternoon, everyone. I'd like to welcome the healthcare professionals joining us from around the country and thank them for all they do every day for all of us and our families. Today's webinar, entitled Why DEA Inspections Are Anything But Routine, is being recorded and will be made available for your future reference. Very briefly, my name is Anthony Mahajan, and I am the founding partner of the Health Law Alliance. I've been a practicing attorney for more than 25 years, including nearly a decade with the Department of Justice, where I prosecuted cases on behalf of the Drug Enforcement Administration. I had a follow-on career in private practice for McKesson and United Health. And since that time, I've founded our firm, which assists healthcare providers and related businesses to expand their business reach through innovative partnerships, compliant contracts, and collaboration on new and emerging areas. We also protect clients facing PBM and payer audits, licensing matters, and other regulatory challenges. Today, I'm humbled to be joined by Nancy Coffey, who knows more about the DEA than anyone I have ever met, either at McKesson while we were dealing with the DEA settlement and independent monitor, or while I was with the Department of Justice and working cases with the Office of Diversion Control, including people at the top like Joe Ranazizi. So Nancy, thank you for joining us. Please tell us a little bit about your career with the DEA.
Thank you, Anthony. And I'd like to thank everybody for joining us. I appreciate this opportunity to speak with you today about an important topic, especially if you're a DEA registrant or work for one. Briefly, I spent 32 years with DEA, first as an investigator for 10 years in the Newark, New Jersey office, where I conducted the investigations we're going to talk about. Then I went to headquarters for a couple of years and then came back to New Jersey to South Jersey to be a manager, where I oversaw some investigations of all the gamut of registrants. From there, I went to the New England Field Division, where I became the diversion program manager, which entailed overseeing the diversion program for the 6 states and the 5 divisional offices that we had throughout New England. And again, I saw every type of investigation, inspection, anything that involved diversion, we were involved in it. After 12 and a half years up there, I came back to Newark to finish my career with DEA for 3.5 years. And I joined the private sector in January of 2021, where I have been testifying and publishing as an expert in national opioid litigation in the cases that have been going on for years. And I was named as an independent compliance monitor by the Massachusetts Attorney General for a current case that is ongoing that involves some Medicaid fraud. And again, thank you, and I hope you enjoy our presentation today.
So just a few disclaimers. Today's presentation is not legal advice. It's for informational purposes only. It is also not attorney advertising. The views Nancy and I will express in this program are solely personal. We do not speak for the Department of Justice or the DEA, despite our prior employment. Nancy, can you give us a high-level overview of what we're going to talk about here?
Sure. Before we dive into the real substance of our program, we'd like to provide you with some necessary background and context surrounding a DEA inspection. DEA investigators regularly visit registrants that are distributors and manufacturers and that type of business. A physician's office or a pharmacy is anything but routine when DEA shows up at your business. DEA is there, they're there for a reason. They're not just there visiting and doing a routine compliance investigation. There could be anything, a compliance concern. It could have been triggered by a prescription monitoring report from one of the states that you're in, or distributing a distributor suspicious order monitoring system report. It could even be a complaint from a disgruntled employee. That happens more often than you think. But the most important takeaway you should understand about an inspection is the first 5 minutes is the most important. How you respond to the investigators and the inspection, it's going to dramatically shape the tone of the rest of your day, if not longer. In today's presentation, we're going to give you an insight that you need to assess the situation and respond accordingly.
Right. So the first 5 minutes, what do you need to think about? Here's what you need to know. There's a number of considerations that you will need to assess in that split second when they walk through the door where you're about to open, and determine how you're going to greet them, how you're going to respond to them. And we're going to explore each of these areas in greater detail, and then hopefully open up the session to field some questions from our audience. And though we have separated these points into different distinct columns and areas, please appreciate that they all overlap and are closely related. They influence one another. So for example, if there are agencies in addition to the DEA present for the inspection, that will inform the range of potential consequences that may arise. Similarly, how you respond will be influenced by the documents that are involved. So let's dive a little bit deeper into each of these areas now.
Okay, your spectrum of inquiry. Basically, it's important to understand that today's DEA inspections are very different from the ones that were conducted even 7, 8, 9, especially 10 to 15 years ago. The reason for that is the inspections back then were more fact-finding. They were looking for information. Given the availability of data that's available now, particularly when it comes to healthcare issues, DEA has extensive info and resources available to them through various state and federal databases, as well as other tools. What used to take time and footwork to find information now can be done at an investigator's desk with the click of a couple keys on their keyboard. For example, DEA is more effectively leveraging the prescription monitoring data that they are able to obtain from the states that are collected. It's very extensive data. DEA is also utilizing their ARCOS reporting system and distributor and manufacturing suspicious order reporting and due diligence efforts a lot more effectively. And this helps them target potential violators, but it also weeds out people that are doing business the right way. Accordingly, before DEA arrives, they're already going to possess much of the information that they need. Like I said, touch of a computer at their desk. Therefore, it's critical that you, as the registrant, you must listen, you really listen to fully understand the focus and scope of what they're asking and what they're looking for. That's key to remember. Are the questions directed towards a physician, a high prescribing physician in the area? That might be easily explained by you. Or is it directed towards patient steering, compliance concerns, or potentially problematic patients? If the inquiry seems to be focused on someone else, a different registrant, the inspection may involve less risk to you than if they are asking very pointed and probing questions and interviewing staff or support staff, or copying a bunch of your records. If the inspection veers more towards the right part of the spectrum on this slide, responses that you give should be more cautious, as this may indicate that you and/or your business are in the crosshairs of the investigation.
Thanks, Nancy. This is a very poignant slide, very illustrative of, kind of the spectrum of inquiry that's out there. I just want to lean into the point you made a little bit about information at the fingertips of investigators. And as I think our audience knows, payers, MCOs, and PBMs all operate special investigative units, or SIUs, because they're obligated pursuant to their government contracts to report potential or suspected fraud to the government. Accordingly, many government investigations, including DEA investigations, arise from referrals by these companies to the government. And what does that mean? What, a little bit of a kind of a look inside is that given the data, and United Health is one of the most data-driven companies out there. McKesson obviously is advancing the dialogue and the controls in industry with respect to suspicious order monitoring. When I was there helping the company build out its program, the data and the heat maps that we had at our investigators' fingertips by zip code, by control class, were quite amazing and very specific. So what I want to point out for our audience is that in addition to the data relating to controlled substances, all of the government agencies, as well as some of the private agencies, are able to cross-triangulate between the medical side and the prescription side, meaning that, for example, at United Health, they have United Healthcare medical benefits, then they have the PBM, Optum Rx. So that gives them data sufficient to know at a pharmacy who are the high prescribers, because they can see that. And they can also see if there is a prescription being filled, is there a corresponding E&M or medical visit on the physician side? So that's a little bit of insight. That just is the tip of the iceberg that you should appreciate is out there when it comes to data. So let's set the stage a little bit more closely on that day when people arrive at your pharmacy. Although a lot will be happening, it's absolutely critical that you understand who has arrived for the inspection and who's responsible for what. So the DEA has both special agents and diversion investigators. They're separate personnel who work on controlled substance matters. In addition, the agency has forensic evidence teams who are responsible for imaging computers and collecting documents. So the point for today that you should appreciate is that if anyone from the DEA is present, other than the diversion investigators, that represents an aggravated risk scenario, and you should think very carefully about how to proceed. Factor that into your analysis, as well as the fact that if OIG, the FBI are out with the DEA, that will indicate that there is something broader underfoot in addition to controlled substances. Now, the FDA doesn't partner often with the DEA. However, for compounding pharmacies, as well as for investigations involving counterfeit products, we've seen the FDA go out hand in hand. Then finally, what we are seeing more and more often these days is that the licensing boards, meaning the boards of pharmacy and the boards of medical examiners, are more frequently partnering with the DEA to go out and to conduct an inspection or investigation pursuant to the licensing board's jurisdiction. And in that regard, it's important to know that they each have different jurisdictions and authority, meaning the DEA is authorized by its enabling regulations and federal law to review matters involving controlled substances. At the state level, whether it be the Bureau of Narcotics in New York or the Consumer Protection Agency in Connecticut or the actual licensing boards, they will have a broader scope available to them, and they have the ability to request records of all different types, whether they be inventory or patient care records. And they can do it on a short time frame, meaning typically about 72 hours before you're required to provide those records. So let's talk a little bit more now about those records requests.
Much like who is present can dictate how this investigation or inspection is going to go, the documents that are utilized by the investigators to gain entry to your business and to look at your records are indicative of how serious it may be. A notice of inspection, which is a DEA Form 82, is the least invasive form. like its name, it is basically just a notice of inspection. It gives you your rights and it tells you that you don't have to consent to an inspection. However, if you refuse consent, you should appreciate that this will likely trigger a more aggressive posture by DEA. We're going to go back to that in a little bit, but you also may be asked to provide additional records by the regulatory state boards and agencies. As Anthony just said, that's becoming more of a routine practice to have them join going into a pharmacy. If you're presented at any time during this visit with a DEA Form 104, a surrender of registration, you should take pause and be very careful, as this form involves a voluntary surrender of your DEA registration. And although it says voluntary, it will be considered for cause. Do not sign this form without considering the complete range of consequences that may occur, that are likely to occur both in the present and in the future. In the event of a refusal to allow an inspection, as we mentioned earlier, should be mentioned that you can allow the inspection and then deny the inspection once, if you are under a Form 82. But if you deny the inspection, most likely the investigators are going to obtain an administrative inspection warrant, which you don't have the right to refuse. An administrative inspection warrant is issued by an administrative law judge, but it doesn't indicate that there is a criminal investigation. But again, you have to comply with that. And the next more serious and most serious form of entry would be a search warrant, which kind of speaks for itself. In summary, depending on the type of document that is used to gain the inspection, there can be any number of potential consequences, which we're also going to get into in the next slides.
Thank you, Nancy. Let me just speak a bit on the Form 104. As a federal prosecutor, we're presented with a wide variety of cases that involve potentially more problematic facts than others. In certain cases where we're in the process of building a case, the DEA may go out with a Form 104. That is, going to be presented as a way of resolving it to the practitioner. And the typical pitch is, you know what you did, you should surrender your license and it'll all go away. That's not accurate. So know that that's not accurate. You sign that 104 and you surrender for cause. That's just the beginning. That's on the administrative side. It can't really be used as an admission, but it's not going to wrap up anything. It's not going to resolve anything. It's solely going to result in a surrender of your license. And so, if, as Nancy said, if at any point during the inspection, there's discussion about a Form 104, you should appreciate that there is something additional that the DEA or other agencies know, and that they believe, and it's not necessarily the case, that your registration is inconsistent with the public interest such that they're asking for surrender. So don't do it. You can do it at any point later after you've figured out, what it is exactly that is the issue. So with respect to the, potential consequences, Nancy, can you walk us through those?
Yes. The consequences, again, going from least severe sanctions to the most severe, a letter of admonition will be issued if minor inconsistencies are discovered, really inventory discrepancies, not serious stuff. You're going to get a letter. It's really not that big of a deal. And these are mostly for first-time issues. But if you have past issues and prior letters of admonition exist that haven't been addressed or corrected, they're gonna up the ante a little bit, and a civil complaint may be filed. That's a higher dollar fines than a DEA administrative resolution might entail, and it can potentially involve outside monitors and periodic audits. Pharmacy and medical professional boards, as we said, they piggyback on a lot of these investigations. Their sanctions can involve licensing suspensions, restrictions, or even revocations. So even though it's not criminal or civil in nature, those are pretty heavy-duty sanctions. Finally, criminal charges would be the most severe results of a DEA inspection, but that's not going to happen on the day of the inspection. And that's typically going to involve a much more complex and broad investigation than simply a DEA inspection. In summary, given the range of consequences associated with a failed DEA inspection, your focus should be on how to respond so that none of these concerns are in play. How to respond. This is big. This goes back to one of the first slides, that the first 5 minutes are very, very important. Now that you understand some of our considerations that should be factored into your response to an inspection, let's talk about how these considerations all come together. First, if possible, you want to assuage DEA's concerns. For example, if you're questioned about that practitioner down the street or in the town that is a heavy prescriber, and the ideal scenario is that you talk frankly and candidly with the investigators and give them any information you have. On the other hand, a more common scenario is that if you answer some of these questions, one or more of them, they could prompt scrutiny of your business in some way. Here again, if DEA is asking about someone else, they may have reason to believe that you have info and may potentially be involved. In other words, there's a very fine line between cooperation and refusal. These inspections are very stressful, especially for the registrant, and if they have never gone through one before. And it's also stressful for all your employees who may be subject to being questioned or having a conversation with the investigators. Just be very professional and know that most people, to walk this fine line, it's very hard. And there's also a potential that if you do provide information to DEA, that info could be misconstrued, as some conversations are picked up differently by each person involved in it. It's very important that you have a witness to any conversation and interaction you have with any of the investigators. And because these conversations are subject to distortion and they're remembered differently by everybody. So please have a witness, and as soon as possible after the inspection is over, it would be good to write your notes down on what occurred in that conversation.
Nancy, if I could
just be very careful about what you say and do.
Apologize for interrupting. If I can just follow up on that last point that you discussed in terms of, how do you respond in the scenario where you're trying to open your business, patients are coming in, your staff is getting things ready for the day, and all of a sudden they're being separated, questioned, you're being asked questions, records are being copied, and trying to walk the fine line between trying to give the DEA the openness, the frankness, the candidness that the DEA is watching you very carefully and evaluating to see if there's any hesitancy. And on the other hand, potentially revealing information that's going to result in sanctions on you or your business. And so in that respect, what I would say is that there are some areas of low-hanging fruit that can be addressed today before you're in this spontaneous posture of an inspection. And specifically with respect to your records and your protocols, more and more, day in and day out, we are seeing an increasing focus by DEA on targeting record-keeping violations for catastrophic fines, meaning in the millions of dollars. And when I was at the U.S. Attorney's Office, a number of cases that I've seen now more recently would have been settled for fairly minor sanctions, meaning $25,000, $50,000 fines. They're not trivial, but today what I'm hearing from the DEA is that one violation, there's $16,000 plus fine per violation. So if you haven't checked in something, or you haven't signed an inventory log, or you haven't checked in something on your CSOS, or you haven't linked it, there's all kinds of complex regulations, or prescriptions are not kept C2s together, those kind of things. It's not just $16,000 because you didn't do X correctly for many years. It's $16,000 every time you didn't do X correctly for many years. So if you didn't sign in that inventory, every time you didn't do that, what DEA's posture is it's $16,000 per violation. Therefore, it's millions of dollars, crippling fines, catastrophic scenario. So, don't be in that position for sure, because at this point, we all know how hot the environment is, how aggressive the regulatory scheme is now. And so there is the opportunity for a little bit of prevention, which is, as they would say in the commercials, priceless when it comes time to feeling comfortable when DEA comes through the door. And so if you haven't done so recently, make sure your protocols are up to snuff. They're tight, and your staff is well trained. They understand red flag identifiers. They've completed training. They've initialed that they've been trained, that they're going to comply with what you want them to comply with, that your records are in order, and that they are being kept consistent with DEA's interpretations of their regulations, which is another matter. Finally, you should know, based on your patient demographics and practice, if you're somewhat of an outlier. And if you are, that's fine. There's many different reasons for that. Just appreciate that, if you are asked, you'll want to have some very clear, cogent reasons for why you are a little bit outside that bell curve. So ultimately, if you do have any hesitation at this point, you should reach out. If you need any assistance thinking through any of these matters, get help, because it's not easy and it's complicated, but you have time to do it before you're in that situation where you're trying to assess these dynamics, where both Nancy and I, 30 years in the industry, even for us, it would be hard to try to figure out and make sense of what's going on at the time and on the fly. So a little bit of prevention now would go a long way. Nancy, if you could just bring us home.
Sure. To wrap this up, this is not an area that most people will get 100% correct, and it kind of mirrors what Anthony just said, particularly if it's your first time inspection, because you're going to be under stressors that you're not used to. I've tried to share with you a little bit of my perspective from decades at the agency. We didn't really have a lot of time for some anecdotes, but from what I've seen now that I'm on the private side, everyone can get a little bit better at process and documentation. Record keeping is key. If your records are in order, there's really not much, it's going to make your life a lot easier if there are some issues, and it's going to make things a lot more minor as opposed to exploding into major things. The basic requirements are attended to that will go a long way towards demonstrating to DEA that you take your obligation seriously and that you are attempting to follow all the regulations. But the stakes are high, and preparation will significantly reduce your exposure to some of these inspections. Thank you for your time.
So great point there, Nancy. Folks, get your blocking and tackling buttoned up. The records, they're very complicated, and DEA is interpreting the CFR in ways that is not apparent from the plain text, and is very specific about each word in those regulations. And if it's not electronically linked, for example, it's not compliant. At this point, the pendulum has swung. You are at risk for much harsher sanctions than you may realize if you don't have everything in order. It's not like the past. The inspections are not like the past, and the sanctions are not the same. So this is definitely not a time in today's environment of intense government scrutiny and harsh enforcement to take any chances. That concludes the substantive part of this program. We do have some time for Q&A. So if anyone has Q&A, they could put that in the chat here, and we could respond as we see that populated. Okay, so Nancy, one question that has been asked is, at what point is consent to an inspection harmful to my business?
Well, I think that's kind of like an inner gut check. Does it feel uncomfortable? Does it make you uncomfortable? But again, you have to weigh your options here, because when I was in the field and an investigator, and certainly when I was a supervisor, if my investigators were at a registrant and they called and said, notice of inspection has been denied, or they granted us and then they revoked the consent, I would be on the phone with Anthony like within 5 minutes, or we'd have a conference call, because we're going to get an administrative inspection warrant issued then, because in most cases, barring, a really good reason by the registrant, that's going to evoke some suspicion. So, but you have to know how your business is operated, and that's basically how we can address that.
So just to kind of follow up a little bit there, Nancy, it's very difficult if you are the recipient of an inspection to say no, right? And so that's all the more reason that as part of your preparation, you have thought about how to implement that plan. And the easy, low-hanging fruit answer to that is to say, once they walk in through the door, welcome, folks. If you don't mind, I'd like to notify my attorney and have him speak to you. So if you have an attorney on retainer, if the attorney says no, that's not on you. You put a barrier in between the DEA and you, and it's not no at all. The attorney will never say that. But we have a way, especially those of us who've come from the government side, of speaking to the DEA, of being able to understand what makes them run and what they're looking for, and how to kind of cooperate fully with them, even if we're not trying to be that cooperative on behalf of a client. So, that's something that gives you a little bit of a insulation from interacting with the DEA directly. I think we have time for about one more question here. So, Nancy, the question is how does a pharmacist document a red flag around legitimate medical purpose? And what is proper documentation and resolution of red flags? Well, that's a fantastic question. And it speaks directly to the so-called corresponding responsibility that pharmacists bear under the law to confirm that a prescription, a controlled substance prescription that they dispense, is written for a legitimate medical purpose within the usual scope of practice. And so as this question indicates, if there is a red flag, you can't fill that prescription unless there is some evidence that's been documented of how you've resolved that red flag. So Nancy, how would you suggest registrants handle that?
Well, again, a lot of this involves documentation. And the first thing that a pharmacist, I think any pharmacist knows to do, is you call the doctor's office. And before you can fill the prescription, you have to explain to him what your red flag is and why it is a red flag for you. And if the physician's response is adequate to you, you have to be comfortable with that. It's a lot of what we talked about today is we called it, walking the line or walking the tightrope. This is one of the tightropes that pharmacists that pharmacists have to deal with. And documentation is the key, because if you show that you documented and you in your professional responsibility, you thought that this was a legitimate prescription and you have documented what the physician said, you're pretty much okay. There's really not much that can be done. I mean, if it happens 100 times a day, that's a different story. But, you know, pharmacists are not infallible, and DEA, and especially I was very aware of that, and I made sure my investigators were.
So thank you for that, Nancy. I'll just answer the final question here. I'll take one more. Thank you, everyone. Really appreciate your interest. What would you recommend a pharmacy do if they become aware that a nearby doctor or clinic which sends prescription to the pharmacy has been visited or audited by the DEA? The answer to that is simple. Get an attorney to review your prescription profile mix, get an attorney to help understand what may be going out. The doctor or clinic likely will have an attorney that your attorney can speak to. And, you know, for example, if you get someone who's familiar with DEA and controlled substances, for example, when I was at McKesson, I know what McKesson looks for. I know what distributors look for in terms of the CS to non-CS ratios, the cash pay, all of those different types of potential outlier data points. You know, you should, you know, understand if for example you are an outlier because of this physician or clinic that has been visited by the DEA, and if so, then you need to do your due diligence and get on top of it and tighten your protocols if necessary, or it could be potentially legitimate. But either way, just going back to the fact that you know what Nancy said, you need to document it. You need to show that you did something about it. All right. So everyone, really appreciate your time and attendance today. Thank you for attending today's presentation. The recording will be available. I wish you all a wonderful day. Thank you.